Well, good afternoon. Let's get started. My name's Austen Parrish. I'm the Dean here at the University of California, Irvine School of Law, and it's my absolute pleasure to welcome you to this year's Moot Court Finals. Before we get started, many people in the audience are admitted students. I think we have over 4,100 applications this year for under about 180 spots, and so getting admitted to the law school is a big achievement. Could we have a round of applause for the admitted students in the audience? We're here this afternoon to witness two outstanding students in their final competition of this year's Moot Court Competition that has been ongoing for many months. So we started with 62 competitors and 31 brief writing teams. 68 attorneys and state and federal judges judged 56 oral rounds of argument. 33 faculty graded the competitors' Supreme Court briefs. Each brief was graded 3 times. And 20 first-year law students served as bailiffs. And so as we begin, since this was a major undertaking, I'd like to begin by thanking the members of the 2025-26 Moot Court Board, Chair Juliana Rosenfeld. I've now started a trend. We're going to have to applause for everybody. So Vice Chairs Daniel Jaffe and Lindsay Busk. Directors of the bench brief, Ahmed Shana and Connor Leonard. Directors of Judicial Relations, Nicholas Liu and Haley Montez. Director of Internal Relations, Sky Reed. And I think there'll be thanks later on, but for the faculty advisor, Professor Peter Tice. I'd also like to thank the Buckhalter Law Firm for their financial support for this competition, and finally the many judges and volunteers who made this year's competition a success. As we move into this competition, we're going to hear from our two finalists, Alex David, who is arguing for the petitioner, and Jared Stone, who will be arguing for the respondent. Let's have a round of applause for them. I'm now going to provide, as our tradition, a quick summary of the case so everybody understands the factual background, and then I'm going to introduce our distinguished panel of judges before we bring in and then start the formal proceedings. So first for the case summary. James Whitaker is a licensed taxi driver and firearms instructor in Lancaster, Pennsylvania. On March 18, 2025, the city enacted a controversial political ordinance that drew intense public attention. 3 days later, large groups of protesters and counter-protesters gathered downtown. Whitaker parked near the protest zone to record the events for his online channel. He lawfully carried a concealed handgun. During the protests, Whitaker became involved in a verbal dispute with a counter-protester, Parker Ellis. Police officers responding to the scene, heard what sounded like a gunshot, discovered a bullet hole in Whitaker's taxi, and arrested him. Whitaker disclosed his firearm and his license, cooperated with the police, and was released that evening without charges. Forensic testing later confirmed that the bullet did not come from his weapon, and the Lancaster City Bureau of Police closed its investigation on March 28, 2025. Despite that closure, the Bureau refused to return Whitaker's firearm and impounded his taxi. Officials cited Directive 2207, a policy governing the return of property seized during, quote, politically sensitive incidents, which require multiple approvals and, quote, a quiet period following any material-related protest activity, even outside of Lancaster. The Bureau also required Whitaker to pay more than $2,600 in storage and towing fees before reclaiming his taxi, amount he could not afford. On April 28, 2025, Whitaker filed suit under 42 U.S.C. Section 1983, alleging violations of his 4th, 2nd, and 14th Amendment rights. The district court dismissed the 4th Amendment claim, but the Third Circuit reversed, holding that a seizure reasonable at its inception may become unreasonable when its justification ends. The Supreme Court of the United States granted certiorari. The question presented is whether the continued retention of personal property must be reasonable under the 4th Amendment when the investigation justifying the initial seizure has been closed and no charges has been filed. That's the issue that you'll hear oral argument on this evening. The judges who are judging tonight's competition are 3 tremendous jurists. Before they join us, let me tell you just very briefly a little bit about them. First, we have the Honorable Anna D'Alba, United States Court of Appeals for the Ninth Circuit. That's right here in California. She previously served as the United States District Judge of the United States District Court for the Eastern District of California, where she had the distinction of being the first Latina district court judge in the Eastern District. Prior to serving on the federal court, she had a distinguished career in private practice and served as a judge on the state bench. Throughout her career, Judge D'Alba was known for a commitment to giving back, and during her 11 years in private practice, she dedicated on average more than 300 pro bono hours annually. Born in Merced, California, Judge D'Alba is proud of her upbringing as a child of immigrant farm workers in California's Central Valley. Next, we'll have the Honorable Brian Jackson, who is a United States District Court Judge for the Middle District of Louisiana. He has also long served as a member of the UC Irvine Law School's Board of Visitors. Prior to joining the bench, he served as an Associate Deputy Attorney General in the United States Department of Justice in Washington, D.C., as a federal prosecutor in the United States Attorney's offices in Baton Rouge and New Orleans, and as a partner in private practice. He also served as the Chief Judge of the Middle District of Louisiana from June 2011 to June 2018. He has the distinction of being a fellow of the American College of Trial Lawyers and a member of the American Law Institute and the Louisiana Law Institute. Active in his community, he serves on the boards of Baton Rouge General Hospital, the Greater New Orleans Foundation, and the All-State Sugar Bowl Committee. Finally, we have the Honorable Monica Ramirez Almadani. She is a United States District Court Judge for the Central District of California here in Santa Ana. Prior to joining the bench, Judge Almadani served as President and CEO of Public Counsel, one of the largest pro bono civil rights law firms in the nation. Prior to joining Public Counsel, Judge Ramirez Almadani spent several years in private practice with the Department of Justice as an Assistant United States Attorney for the Central District of California, a Special Assistant Attorney General in the California Department of Justice, and as a Senior Advisor to then California Attorney General Kamala Harris. She also taught at UC Irvine School of Law, where she was a visiting clinical law professor and co-director of the Immigrants' Rights Clinic. After reading the bios, I see our competitors are sweating. Those are three amazing careers. With that brief introduction, I'm going to turn it over to the bailiff to begin this year's final oral rounds of oral argument. Thank you so much for joining us this afternoon. Sorry, I have strict instructions.
Everyone may be seated.
Hear ye, hear ye. The Honorable Court is now in session. Chief Justice D'Alba presiding, alongside Justice Jackson and Justice Almadani.
Good afternoon, everyone. We are so excited to be here. As you just heard, I am Judge Ana de Alba, Justice now. I've been promoted to the Supreme Court, quite exciting. I, along with my colleagues, Justice Brian Jackson and Justice Monica Ramirez Almadani, welcome you to UC Irvine School of Law's 2026 Moot Court Competition. I'm now going to ask both judges to please give you a short introduction of themselves. So, Justice Jackson.
Thank you, Chief Justice. And I too appreciate being elevated to the Supreme Court here. My name is Judge Brian Jackson. I actually sit in the Middle District of Louisiana, which is in Baton Rouge, Louisiana, and I've had the privilege of serving on the Board of Visitors here at the law school for a number of years, and I'm honored to be here, and so thank you all again for inviting me to participate.
Thank you.
Good afternoon, everyone. I am Judge Monica Ramirez Almedani. I am a district judge here in the Central District of California. My chambers and courtroom are here in Santa Ana, so in Orange County. And I'm honored to be back here at UC Irvine. I taught as a visiting clinical professor at UCI in the Immigrants' Rights Clinic for 2 years. And so I'm always excited to be invited back and excited to see current students and prospective students and just absolutely love UCI. So thank you.
Wonderful. And quick introduction about myself. I am a current judge on the Ninth Circuit Court of Appeals. My chambers is in Fresno. This was my first trip to UCI. Beautiful campus that you have here. So thank you so much. And we're going to go ahead and begin. I'm going to call the matter of Lancaster City Bureau of Police versus James Whitaker, case number 25714. Each side will have 20 minutes. If the petitioner would like to reserve time for rebuttal, please be aware that you are responsible for keeping track of your time. Ms. Davis?
Yes, Your Honor.
Thank you. You may begin whenever you are ready.
Your Honors, this is Alex Davis representing the petitioner today. And before I begin, I would like to reserve 4 minutes for rebuttal, please. Thank you. May it please the court. The right to property is fundamental. And petitioner is not here today to dispute that or to suggest that respondent shouldn't have a way to get his property back. Rather, the issue before this court today is much narrower. Once property is lawfully seized and retained, what is the law that governs? And to this, petitioner respectfully requests this court to reverse the ruling of the Third Circuit Court of Appeals and find that the continued retention of personal property, once it has been lawfully seized, does not implicate the Fourth Amendment.
Counsel, let me ask, how long does that go for? Forever?
The length of a seizure, Your Honor?
No, the length of being able to keep the property after the fact without additional justification.
Without justification, Your Honor, it is petitioner's contention that this is governed under the due process framework, balancing the private interests of the individual as well as the government's interest in potentially fiscal, administrative interests, processing that evidence, collecting storage fees, under that framework, Your Honor.
But counsel,
Go ahead, please.
can you properly characterize the vehicle and the firearm as evidence at this point, at this stage of whatever investigation was underway? I mean, the investigation has been concluded without the filing of criminal charges, so how is it deemed to be evidence at this stage?
Well, Your Honor, the property was evidence, as Your Honor mentioned, on March 21st when it was initially taken for the investigation. And then when the investigation ended on March 28th, it was no longer evidence, but it was seized due to petitioners and held due to petitioners' administrative, public safety, and fiscal interests. There were public safety interests concerning the firearm under an internal policy, Directive 2207, because there were materially related protests that were still ongoing. And petitioner had previously suffered an incident after returning a firearm, and it was immediately used to kill a bystander. As for the vehicle, there were administrative and fiscal interests to collect the towing fees that the vehicle had been sitting in the satellite storage lot for, as well as processing that evidence. Those were the interests that warranted petitioner keeping that property, which is again balanced under that Matthews framework.
So counsel, talk to me a little bit about these fees that are being incurred. Is it just a one-time fee to get the car out, or are these fees ongoing because Mr. Whitaker can't afford to take the car?
Yes, Your Honor. These fees are ongoing. They accumulate at a daily rate. So by April 28th, or by April 18th, excuse me, those fees had accumulated to $2,645. And we recognize that this is a harm to respondent because that taxi was his livelihood. He wasn't able to make money, which is why petitioner believes it is so important that this is balanced under a framework that can account for those burdens on his interests. Under the Matthews framework, it can account for not only the interests at the moment of the taking, which is what the Fourth Amendment focuses on, but the interests as they accumulate as time goes on. For example, in City of Los Angeles v. David, this court evaluated a very similar claim where a car was seized and it was held for an elongated period of time, and its return was conditioned on towing fees and storage fees. And what this court did was evaluate it under the Matthews framework, balancing not only the interest at the moment the vehicle was taken, but as days went by, that private interest, the burden on that person's private interest, it increased. It increased over time, just like with Respondent. It increased over those 29 days he was unable to drive that taxi cab and make that income to pay those fees.
But Counselor, if we're considering the government's interest, as you say, why can't we consider the individual's interest under a Fourth Amendment analysis? So I'm not understanding why your definition of seizure is so limited.
Yes, Your Honor. It is petitioner's contention that a seizure is limited to the moment of the taking. And this is also because when this court created the standard for determining what is reasonable, that test was this. It was limited to the facts that existed at the moment the property was taken, and whether that would warrant a man of reasonable caution to believe that taking that property was appropriate. Thus, what the Fourth Amendment reasonableness test focus on is only those interests that existed at the moment of the taking. Thus,
And those interests disappear even if the government is holding on to the property indefinitely?
those interests absolutely do not disappear, Your Honor. However, what the Fourth Amendment cannot do that the 14th Amendment does is the Fourth Amendment only considers the interests as they existed at that very moment the property was taken. At the moment the property was taken, the harm on Respondent may not have been as great because he only lost the vehicle for that moment. However, under the Matthews framework, it can assess how that interest, that burden on his private interest increased over 29 days, from March 21st to April 18th, which is why petitioner believes this is not only the true framework, but also a more favorable framework for Respondent's claim.
But under that analysis, could that lead to perhaps an unintended result, where there's a permanent deprivation of the property? I mean, you have now a person, a citizen, who relies on that cab to make a living, and now is deprived of that opportunity to make a living, and may never be able to afford the kinds of fees that the city has imposed. Is that really what the ordinance or the county or the state want to do?
That's absolutely not what the state wants to do. With Directive 2207, the aim was absolutely not to permanently deprive someone of property. Rather, again, its aim was public safety. But looking at that policy and whether or not it was fair to Respondent, under the Matthews framework, the second prong of that is the existence of adequate procedures for a person to gain their property back. What due process in the Matthews framework does is it considers those existing procedures and whether or not they permanently deprive somebody of property or whether they provide a proper channel for them to get their property back. It accounts for those permanent deprivations.
Even if it's shown, even if the state is convinced that this item had no nexus to a crime?
Yes, Your Honor, because there were, again, public safety interests, because the last time the state had returned a firearm to somebody and there were still materially related protests ongoing, an innocent person was killed.
I understand that, but I'm talking about the vehicle itself. I mean, as far as I can tell, there was no connection between a crime and the vehicle. Would you agree with me?
Well, initially on the day it was taken, there was probable cause to believe so, but on March 28th, I agree with you, Your Honor, there was no crime committed. Now, going back to petitioner's first point today, the reason why the seizure is a single act and not a continuous fact is first looking at the historical definition of what a seizure was understood to be at the time the Fourth Amendment was ratified. There are historical dictionary definitions that support this. For example, Noah Webster's 1828 dictionary defined a seizure as a, quote, act of taking or act of laying hold on suddenly. And this was the first American dictionary that was published after the Fourth Amendment was ratified. Additionally, in the Oxford English Dictionary, this defined a seizure as a sudden and forcible taking hold of land or goods. And this definition is also extremely important because it cited two historical pieces of evidence to support this meaning. One from 1701, the 10th report of the Historical Manuscripts Committee, but second, volume 4 of Edmund Burke's Communications in 1793, just 2 years after the Fourth Amendment was ratified. This provides historical evidence that at the time the Fourth Amendment was created, a seizure was understood to be that limited, momentary, discrete act of taking hold of property. Additionally, this court has also made that very clear in its own precedents. Starting in 1862 in Thompson v. Whitman, this court defined a seizure as a single act, not a continuous fact. Possession, which follows seizure, that is
doesn't
continuous.
apply to the seizure of a person, correct?
That is not
So
to a
that's,
seizure of
that's a
person.
distinction that you're making.
Yes, Your Honor.
Okay, and so help us understand why that distinction is relevant here. Why we shouldn't follow our precedent with regard to seizure of persons, in which we have found that that seizure doesn't end if the person is still being held, then their Fourth Amendment rights are implicated, correct? So
Yes,
why is
Your
it
Honor.
different when it comes to effects?
Yes, Your Honor, and that is also the petitioner's understanding from Manuel. However, a petitioner has two reasons why this court should not expand the definition for persons of a seizure to property. That being this court's own precedents already employing very different standard for seizures of persons and property. And second, that retention of property doesn't implicate the same liberty and privacy interests as when a person, a human being, is detained.
Counsel, can I ask you, does it matter what the property is? So is a cell phone, should we treat a cell phone differently than we treat a car, a gun?
It absolutely should be treated differently, and that is something, again, that can be balanced under the Matthews framework as to the value of that property, the importance of the property to the person and their livelihood. However, when it comes to property effects as a category under the Fourth Amendment, that should all be treated the same, subjecting it to the Matthews framework. Now, going back to those two reasons I mentioned, first, this court's precedents make it very clear that persons and property should be subjected to different standards of what a seizure is. As we know from U.S. v. Jacobson, a seizure of property occurs when there is a meaningful interference with one's possessory interests. However, as this court defined in Torres, a seizure of a person occurs when force applies to the body of a person with intent to restrain, even if that person isn't actually physically subdued, as it occurred in Torres when police officers fired gunshots at an individual. She was struck twice. She was able to drive 75 miles away before the police caught up to her. However, that seizure took place the instant those bullets struck her, when physical force was applied to her body with intent to restrain. Thus, this court and its precedents have never applied the same standards for persons and property, and doing so today would be a significant departure from stare decisis. And the reason for these different standards is because there are fundamentally different interests at stake when a person is detained versus when property is held. Detention of a person implicates liberty interests and privacy interests. It restricts movement, imposes physical control, raises concerns of coercion, humiliation, dignity, invasion of privacy. These are deeply personal and unique human harms.
Well, I understand that, counsel. I don't see, I realize that this is different, but I don't think it's that different. If I take someone's taxi, and that's what they do for a living, I'm taking away their ability to survive. If I keep their phone, maybe they have photographs of their children on their phone, maybe they have other things that are very personal to them on their phone. And maybe it's information that may be embarrassing to be, made public. So I'm not sure I'm really on the same page with you regarding treating persons versus property differently, especially when you're telling me, well, property, judge, you can hold it forever without a continued justification for it. Yes, you have to look at it under Matthews, but unlike a person where we do have to have a continuing justification to keep them, we don't have to do the same for property because of all these, outside factors. Well, those factors apply as well, depending on what the property is. I'm taking someone's livelihood.
Yes,
You've
Your
taken
Honor.
the taxi driver's livelihood.
Yes, Your Honor, and it is petitioner's view that in that regard, of course, it does impact a person's livelihood or maybe even their privacy with a cell phone in that way. However, what taking property does is, when property is held, it infringes on a person's possessory interest in that property, not the person's physical liberty interest in their ability to move, which is why this court has created different standards for reasonable suspicion and probable cause, because reasonable suspicion does implicate those liberty interests when a person is unable to move around in that way. Whereas holding a taxi cab in a storage lot or a firearm in an evidence locker, the property itself, it can't be subject to coercion or humiliation or indignity in the same way that a person would be, which is why petitioner urges this court not to depart from its precedents and apply the same standard for both.
What precedents are you referring to? And are those holdings
Yes,
of
Your
this
Honor.
court or dicta?
Holdings of this court, Your Honor.
Which cases are you relying on?
From Torres, as mentioned previously, that there
That
are...
dealt with the seizure of a person.
Yes, Your Honor.
Okay, so what is your best case on why we should draw this distinction between persons and effects?
There are two cases, Your Honor. One is Manuel, in which this court states that there are seizures that may be unreasonable to persons that are reasonable as to property, drawing a distinct line that one could be reasonable because of those interests and one may not be. Additionally, Terry v. Ohio, this court stated, "No right is more sacred nor is more carefully guarded than the right of every individual to be free from control, outside control of his own person, free from all restraint or interference from others," highlighting the importance of the right for a person to be free from outside control or restraints on that in that way. Additionally, as Your Honor mentioned the due process framework earlier, it is also petitioner's contention that there are additional remedies for plaintiffs bringing these Fourth Amendment claims, that there are state remedies in that way.
Well, let me ask you this. It seems to me, counsel, that a citizen may be penalized by this assessment of a fee just to assert a constitutional right, a fundamental constitutional right. I believe you, at the beginning of your argument, acknowledged that possession of property of this time is a fundamental right. You don't pay a fee for a Sixth Amendment jury trial. You don't have to pay a fee, for instance, typically for most Fifth Amendment due process, Fourth Amendment. You can go down the list of these fundamental constitutional rights that are available to every citizen and many non-citizens, but they don't have to pay a fee. So why is it that, given that, unlike some of the cases you cited, there were no filing of any charges, no cocaine, no drugs found, nothing, no illegality whatsoever found with respect to the taxi? Why should this citizen have to pay money to a governmental entity simply be repossessed of the constitutional right, I should say, to be repossessed of his own personal property?
Yes, Your Honor. It does look like my time is up. May I have a moment to answer your question?
Please.
It is not petitioner's contention that a person should have to pay those fees, especially if they're subject in Directive 2207, any materially related protest activity anywhere in the nation. However, it is petitioner's view that someone should be able to challenge those fees to show that they have these heightened burdens on their private interest. Paying towing fees is a private interest. Thus, it is still petitioner's contention that the 14th Amendment is the correct place to bring these claims, to take into consideration not having to pay those fees, not having to lose money in that way. And for that reason, petitioner asks this court to reverse the holding of the Third Circuit. Thank you.
counsel. Mr. Stone, whenever you're ready.
Good afternoon, Your Honors, and may it please the Court. My name is Jared Stone, and I represent the respondent, Mr. James Whitaker. The parties agree that Mr. Whitaker has a procedural due process right under City of West Covina. But knowing how to get your property back is a very different question than having a substantive right to the return of that property. The answer to that latter question must be at least the Fourth Amendment for three reasons. First, because the amendment's text, history, and traditional understanding all demonstrate its application to the retention of seized property. Second, because two lines of cases from this court's modern precedent, Place, Jacobson, and Segura, as well as United States versus Jones and Manuel versus City of Joliet, each independently established that the retention of property by petitioner here was a seizure. Finally, third, the rule the respondents propose is straightforward, easily applicable, and produces beneficial public policy outcomes. I'd like to start with the text of the amendment, unless the court would prefer to start elsewhere. My friend on the other side talks about the original public meaning of the term seizure, and I think the petitioner gets it half right. We don't contest that one of the definitions used in Webster's dictionary absolutely refers to the act of seizing or the act of taking possession. But Webster's, like 6 other founding era dictionaries, my apologies, all also define seizure as the thing seized or possession itself. We'd refer to this as the act-state definition of seizure. That is to say, a seizure is both the act of seizing and the state of having been seized. That's confirmed by the modern version of Merriam-Webster's dictionary, which explains precisely that. A seizure is, quote, the act of seizing or the state of being seized. And it traces that definition back to the 15th century. At a minimum, the text is ambiguous and requires history to resolve it, but we think it squarely supports our interpretation of the amendment. Turning now to history, for over 100 years since Carroll versus United States, this court has made clear that the Fourth Amendment is to be construed in light of what was regarded an unlawful search or seizure at the time of the founding.
Let me stop you there,
Sure.
although I appreciate the historical lesson, but let's focus here on what stops your rule from turning every property return dispute into a Fourth Amendment case.
Sure. I think there are 3 limiting principles. I'm happy to step back and have a broader discussion about the precise contours of our rule. So first, in terms of how we weigh it, it's the same standard in Jacobson and Place, which is that courts should weigh the nature and the quality of the intrusion on the individual's Fourth Amendment interests against the governmental interests alleged to justify that intrusion. It's the standard totality of the circumstances test that this court always uses. In terms of endpoints, there's 2 that we identify. The first is obvious when an individual actually gets their personal property back. Obviously, the Fourth Amendment drops out. The second place is the initiation of in rem forfeiture proceedings, where the guilt assessed is the guilt of the property itself, not the underlying individual who the property was originally associated with. In terms of limiting principles related to that rule, we'd offer 3. The first is that the question presented is an inherently narrow one, and if it wanted to, this court could rule on narrow grounds, confirming the amendment's application solely after the closure of a criminal investigation. Second, we would say, and this goes back to history, and I'll explain it a little more in a second, but because this court looks to common law analogs at the time of the founding in fashioning the rules and elements of a 1983 claim for a constitutional violation, we would offer that the common law analog torts, like replevin, detenue, and trover, all generally required a showing on the part of the individual who wanted their property back that they actually made some sort of what was termed a seasonable request. So it's not a pure exhaustion requirement like procedural due process per se, but it's almost like a pseudo-exhaustion requirement that requires you to at least show you asked once, right? And we think that takes away many of the most frivolous cases where a person almost intentionally attempts to manufacture a Fourth Amendment violation by choosing not to go to law enforcement and ask for their property back.
So let me ask you, your
Sure.
opponent argues that there should be a balance of factors here, a
Sure.
balance of interest. Are you suggesting that it's improper for the court, at least for our duty here,
Sure.
to consider factors that weigh in favor of the state?
Not at all, Your Honor. We're perfectly willing with the court confirming the threshold question that the Fourth Amendment law applies, and then the petitioner making the arguments about the public safety rationale and the necessity to collect towing and storage fees on remand in the district court. But those aren't reasons to say that the Fourth Amendment simply doesn't apply to the retention of property. And then finally, I want to just give you one more limiting principle as
Counsel,
well.
I
Sure.
apologize for interrupting, but so if we rule in your favor,
Sure.
what's going to happen to due process claims? Do they become redundant? I mean, what?
Yeah, so our frontline position would be what this court said in Soldal and United States versus James Daniel Good Real Property, which is that when a single act potentially violates multiple constitutional provisions, the court's task is not to determine the predominant nature of the claim, but rather examine the merits of each claim in turn. So on a principled level, we'd say that the merits of Mr. Whitaker's Fourth Amendment claim or the merits of his procedural due process claim simply do not have bearing on one another. In terms of the practical, I do recognize that our rule would, in some respects, incentivize individuals to bring a Fourth Amendment 1983 claim because it would get them around the exhaustion requirement. That's in part why we suggest that second limiting principle, because it, to a certain extent, requires that the police actually effectively be put on notice that this individual wants their stuff back, right? So, turning back to history, if I may. This court, in a line of cases throughout the 1990s, made very clear that one of the ways to determine whether a right has been violated under the Fourth Amendment is by asking whether the common law at the time of the founding would deem it an unlawful search or seizure. Here, Blackstone identifies those three torts that I mentioned earlier, all as, quote, actions where the injury is in the unjust detaining, though the original taking was lawful. That first action, replevin, provided damages like a 1983 action would here. The second, detinue, in Blackstone's words, provided, quote, a regular method to recover possession where, quote, the injury consists in the detaining and not in the original taking, precisely the injury we allege here. And finally, and we think this is maybe the most important one, trover could, quote, be brought against any man who had in his possession by any means whatsoever another's property and who, quote, refused to deliver it when demanded. Indeed, Aziz Hook, the Fourth Amendment scholar, explains that in the early Federal Republic, seizures by federal revenue officials were challenged in common law actions such as trover. And we even have two different examples from state Supreme Court cases at the time, the first being Clapp versus Bell from the Massachusetts State Supreme Court in 1808, the second being Johnson versus Edson from the Vermont State Supreme Court in 1827. In both of those cases, a local sheriff retained possession of an individual's property, and the courts sustained a trover action against the sheriffs because once the justification for the holding onto the property had dissolved, they had a legal obligation to return it to its proper owner.
Thank you, I appreciate that. So let me ask you then, is it enough for the government to just articulate any rational basis now, just to keep the property? Or does it have to be somehow closely related to the law enforcement needs?
Yeah, we would generally say, in terms of Fourth Amendment reasonableness, it would probably have to be related to some sort of a law enforcement need. Additionally, we would also say that it isn't just the substantive justification, but also other conditions. So for example, here, one of the failures that we think makes this an extremely unreasonable retention of property is that the same individual who spoke to my client on the phone repeatedly, Lieutenant Collins, was the individual who closed the investigation. So she had full knowledge that the investigation was closed when she spoke to my client on multiple occasions, right? So it isn't even just the balancing of the substantive justifications, it's the totality of the circumstances beyond that as well.
In your case, they also reopened an investigation, correct? So what are we to make of that? Does the continued retention remain unreasonable?
No, Your Honor. We're fine accepting that the city had probable cause on April 18th. What we're specifically challenging is the period from March 31st to April 18th. That is, the investigation was closed on the 28th. March 31st was the first day that my client made a request for property and made repeated ones throughout that period.
What is the remedy that you're seeking?
So we're seeking both injunctive relief and damages here, right? Damages for the dispossession period.
For that 1 month period?
Yeah, exactly. Briefly now, just on tradition.
Well, let me ask you this,
Sure.
though. And you argue that, and I think there's no dispute about the fact that there came a point in time when there was not a criminal investigation underway. Mm-hmm. And you believe it was at that point that your client should have been repossessed of his property.
Not exactly. So the investigation closed on the 28th. We're even willing to give the city that 3-day period from the 28th to the 31st because my client hadn't actually asked for his property yet, right? We think that's the sort of reasonable delay that the Fourth Amendment sort of is okay with in terms of evaluating the reasonableness of returning seized property. But at the point where my client indicated that he wanted his property back and did so not once, not twice, but multiple times, that's where the substantive justification.
So suppose as is very often the case, law enforcement investigations take a lot longer than a few days. They could take sometimes weeks and months.
Sure.
You're not arguing that if your client's property was retained for several months, that would be unreasonable and unconstitutional, are you?
Well, I have 5 different circuit court cases that say so. So the first is United States versus Smith from the Second Circuit in 2020, where they said that a 31-day retention of a tablet before ever seeking a search warrant to search it was unreasonable.
Well, let's not talk about, I'm not talking about the search of it, but to the extent that the investigators may nonetheless believe that there is some connection, some nexus between that item and a crime that is still being investigated. Are you arguing that the item, in this case the taxi, should be returned well prior to, at least hypothetically, well prior to the conclusion of an investigation?
No, Your Honor, and my apologies for not being clear in my answer. When I refer to Smith, I refer to those cases all saying that it was the interference with the individual's possessory interest that was implicated. Because obviously, if the search was never initiated, then there was no interference with the privacy interest. And I think that actually underlies a broader problem with my friend's interpretation of the amendment. Because if the amendment truly just referred to a taking possession, it would be reasonable for law enforcement here to rapidly load my client's taxi cab onto a tow truck, quickly drive it to the impound lot, and wait 10, 20, or even 30 years before effectuating the ballistics report that would determine my client's innocence. Because if my friend is correct that a seizure is merely the taking possession and it's only about that initial period, then there would be no privacy interest and no property interest implicated in that 10 to 30 year gap. We think this is clearly on its face unreasonable within the terms of the Fourth Amendment. Modern precedent confirms this. Start with the line of cases from Place, Jacobson, and Segura. Now, admittedly, these cases aren't precisely on fours in terms of the facts, but we cite to them for the Fourth Amendment principles they espouse. That is to say, first, we think that the retention of property is a seizure because it does constitute a meaningful interference with my client's possessory interests in his taxi and firearm. My friend on the other side points out the fact that this is simply a different standard than the one used to evaluate seizures of property, but this sort of begs the question. If we agree that Jacobson is the standard here, why doesn't it apply? Clearly, my client's possessory interest was interfered with inasmuch as he was entirely dispossessed of his primary source of livelihood and his constitutionally protected, lawfully registered firearm. Indeed, cases like Place, Jacobson, and Segura all independently confirm the principle that a seizure's length alone is enough to make it unreasonable. Jacobson does that at footnote 25. Segura does it in 2 places, but all 6 justices who considered that question nonetheless confirmed the amendment's applicability there. And so I think that's particularly important because when we turn to the cases of Jones and Manuel, I think my friend's logic for differentiating between Manuel and our case here kind of falls apart. My friend on the other side says that Manuel is different because it employs a different standard and refers to the seizure as a person, and the primary justification is just that liberty interest is just different and it's heightened. But this court's already rejected that twice. First in Sodal, and second in United States versus Jones. So Sodal's been described as, quote, the quintessential seizure without a search. And there, the court made explicitly clear that the privacy interests and property interests the Fourth Amendment protect are not a 1A and 1B, but a 1-1 interest. And Jones confirms this. There, Justice Scalia made quite clear that, quote, the text of the Fourth Amendment reflects its close connection with property, and that the Fourth Amendment, for most of its history, displayed a particular concern for its enumerated portion, that is, persons, places, and effects here. As such, we don't think that there's any meaningful way to differentiate between Manuel and our case at hand. And I think there's an even more important way to understand Manuel and the Torres and Hodari D line of cases. So my friend on the other side cites Thompson, but inasmuch as this isn't a Fourth Amendment case, as Justice Ginsburg recognized in footnote 3 of her Albright concurrence, but rather a statutory interpretation case using the term in a tight time and site-specific context, we don't think it controls there. However, we absolutely recognize that Hodari D did cite to Thompson. And so then the bigger question is, how do you resolve Hodari D and Torres with the rest of this court's Fourth Amendment jurisprudence? Here's
Counsel,
how
let me just
Sure.
ask you this, and I'll let you get back to that.
Sure.
But I'm trying to understand why you believe it so critical that that this it should be resolved on Fourth Amendment on the Fourth Amendment rather than the due process. I mean, you would agree that you have other constitutional remedies available to you, correct?
We'd agree with that, and we'd say that those remedies exist independent of any Fourth Amendment violation here. That is to say, the merits of those claims don't have any bearing on the threshold question of whether the amendment applies.
Okay. So is this a case where and there's nothing wrong with it, trying to make new law as you see it, or is it to achieve some sort of satisfactory remedy for your client? You've identified the remedies you're seeking, but aren't those same remedies available without the Fourth Amendment analysis here?
I understand Your Honor's question. In that sense, sure, we're trying to make new law and have the Fourth Amendment be properly recognized within its historical context. And I think that more just broadly reflects the reality that this court's seizure jurisprudence has historically focused primarily on seizures of persons rather than seizures of property. That is to say that we simply haven't had occasion to deal with a case of this kind before this court before.
And let me ask you this.
Sure.
Was the delay in returning your client's property unreasonable as a matter of law? Or are you arguing that this needs to be returned to the district court for some fact-specific balancing? And then what does that balancing look like under the Fourth Amendment?
We do think it's the latter, and we think that it's as such because we're here on a motion to dismiss. We haven't had any opportunity to conduct discovery, and we feel very confident that discovery will show the intentional conduct of the petitioner, right? And so in terms of weighing those facts, I think that just goes back to the same sort of test that we gave you before. It's the nature and the quality of the intrusion. Now, obviously, sort of doing this fact-balancing analysis is hard, but this court has already trusted district courts in the Fourth Amendment excessive force contests to, quote, wade through the fact-bound morass. And so we think these claims are much simpler, and so the sort of practical difficulty of applying the rule is not a reason not to recognize the Fourth Amendment right here.
Counsel, I have a hypothetical for you because
Sure.
I'm kind of stuck on this idea of cell phones because
Okay.
our whole lives are on cell phones. So a cell phone is seized, the case is closed, but the police keep it to copy the digital evidence. What factors should we determine, or what factors should we look at to determine how long that continued retention remains reasonable?
Sure. So I would argue that an individual has a heightened possessory interest in their cell phone for precisely the reasons you identified, Chief Justice D'Alba. That is to say, they have their photos of their children, they might have important identification, credit cards and the like, they might need it for work. And so I think it would be fair to say that an individual's possessory interest in something like a cell phone or maybe, say, a passport would be heightened compared to other forms of property that could be more easily and routinely replaced. And then in terms of kind of the length of time, so first, in terms of the copying of the data, that would probably constitute a search that could be independently evaluated for Fourth Amendment purposes. But in terms of the specific retention itself, I think Austen is very instructive because there, DC MPD retained phones for months, if not years at a time. We think that's clearly unreasonable.
But what things am I supposed to look at then to determine whether it is reasonable? What are some of my factors?
Sure. So I think some common factors in terms of the individual side would be the importance of the property, its sort of fungibility and the ability to easily replace it, and its importance in an individual's daily life. So here, my client needed his taxi cab for the sort of daily occurrence. We'd also say you probably have a heightened interest in property that is implicated by other amendments. So if law enforcement seized First Amendment protected materials, you probably have a heightened possessory interest in such materials because of the independent constitutional protections. And then on the other side, I think some of the things that you can weigh in terms of reasonableness are the length of the delay, the substantive reasons why. Is it just simply that a piece of paperwork was misfiled or someone sort of dropped the ball? Because if that's the case, that goes back to our third limiting principle, which is that negligence under this court's precedent would be a state tort law, and it would require intentional conduct for something to arise to a Fourth Amendment violation. That is to say, you would have to be intentionally depriving someone of their property for a substantive reason, not merely sort of forgetting or allowing it to fall through the cracks.
So could you have a Fourth Amendment violation here, but not a due process violation? I'm just trying to think again about what this balancing test looks like under one amendment versus the other, and practically speaking, what a district judge is being asked to do.
Sure. I think you could, because I think it's entirely possible, as the DC Circuit recognized, to have a hypothetically perfect process where at the end there's simply just a lack of substantive justifications for the reason why that person had to go through that process in the first place, right? So that's I think the cleanest answer there. So briefly just on Hodaridi and Torres, turning all the way back to it, I think the simplest way to resolve those cases is by pointing out that they rely on the common law of arrest and referring to what Chief Justice Roberts called the unremarkable proposition that even my friend agrees with, that the nature of a seizure can depend on the nature of the object being seized. That is to say, persons capable of fleeing and with an interest in doing so, as Chief Justice Roberts explains, obviously would attempt to run from law enforcement. Thus, a seizure in terms of the taking possession of an individual by force may be a single, small, isolated act, but simply not so once an individual has been retained in custody like Manuel was, or like my client's taxi and firearm were here. At bottom, there are three independent ways for this court to recognize a Fourth Amendment right in this context. If it feels the text of the amendment is enough to resolve the questions, then it can rule on text. If it feels that history, particularly the common law, shows that the petitioner's conduct would be considered an unlawful search and seizure at the time of the founding, it can rule on history. Or finally, third, if this court agrees with Place, Jacobson, and Segura, or Jones and Manuel versus City of Joliet, it can confirm using modern precedent the Fourth Amendment's application here. For all these reasons, we urge the court to affirm the Third Circuit below. Thank you.
Thank you, counsel. Thank you, Ms. Davis. You reserve 4 minutes for rebuttal.
Yes, Your Honors. May I proceed?
Yes.
The right to property is again fundamental. And once again, petitioner is not here today to dispute that, but to simply state that respondent is bringing this claim under the wrong amendment. Because where petitioner would like to direct Your Honor's attention is the practical implications of adopting respondent's proposed reasonableness framework today. Because Your Honors raised some important questions during respondent's argument. For example, what factors would judges practically implicate in deciding whether or not retention is reasonable? Does the government have to say that it is rational or simply crime-related? And additionally, practically speaking, what is a judge supposed to do without a distinct standard? And to this, respondent said, we would probably say that it was law enforcement related. When Your Honor, Justice Alba asked about factors, respondent said it could be fungibility, it could be importance to daily life, it could be length, but all of these are mere possibilities. They weren't supported by any precedential case law, even from the lower circuits. These were potential factors that courts could consider if they wanted to, because currently there is no established framework for how a judge would apply reasonableness to the duration of retention of property.
So let me ask you, there was I guess, a so-called cooling off period
Yes,
that
Your Honor.
applied here. You don't think that that was a reasonable period, if whatever that period was?
It may or may not be reasonable. However, once again, the Fourth Amendment is not the correct mechanism to evaluate this because there's no standard to evaluate whether or not this cooling off period was reasonable. There's no case law, no precedent, no statute that says it must be crime related. That was simply something respondent offered to you. Reasonability could be public safety justifications. A court may consider fiscal interests. A court could consider a lack of personnel or evidentiary burden in this case. The issue is that there is no workable standard as to how to apply
But isn't
reasonability.
that why you need the Fourth Amendment? How do you police those administrative delays, for example? If there's no longer any justification for holding the property,
Yes, Your Honor.
then don't you need some kind of way to police that?
Absolutely.
And is that the due process clause, or is that the Fourth Amendment, given what you just stated, that there could be all these different reasons why the property's not being returned?
Yes, Your Honor. It is petitioner's contention that there is no framework to evaluate whether this
But
kind of delay.
we can create frameworks, correct, based on the underlying principles here?
Yes, Your Honor. It is petitioner's contention that it would be due process as well as state remedies, because this is the structure that this court has emphasized, where state remedies have first priority in governing property retention, followed by federal law only serving as a constitutional backstop if those remedies aren't available or adequate to be used. And the key part about the 14th Amendment is that it contains an exhaustion requirement, where state remedies must first be used or attempted or shown that they're not adequate before you can bring that federal claim and jump to federal court. Whereas the Fourth Amendment doesn't have this kind of exhaustion requirement.
Counsel, I want to ask you, I know your time is almost up, but I do want to ask you this. So in your view, does the Fourth Amendment ever regulate anything after the initial acquisition of the property?
No, Your Honor. It is petitioner's view that Fourth Amendment only governs that initial act of taking possession.
So if the property is destroyed, it doesn't come under the Fourth Amendment? If the property is altered, it doesn't come under the Fourth Amendment? If there's a conversion of the property, that's not governed by the Fourth Amendment?
Your Honor, I see my time is
You
up.
may
May I
respond.
answer? Yes, Your Honor. It is this court's contention that a meaningful interference with a possessory interest, which is what this court defined as a seizure, that's a seizure under the Fourth Amendment. And meaningful interferences can also include an act of destruction, an act of alteration, as this court held in Jacobson, which is why in that case this court performed two separate seizure analysis, one for the initial taking of the property and a second analysis for that destruction of property, a new discrete act that interfered with one's possessory interests because it converted a temporary deprivation into a permanent one.
Okay.
And for those reasons, petitioner respectfully requests this court to reverse the ruling of the Third Circuit. Thank you.
Thank you. The court would like to, The court would like to thank counsel for that very useful argument, and court is now adjourned.
All rise.
You may be seated.
Wow, wasn't that exceptional? Let's have another round of applause for Alex and Jared. So you all just saw 20-minute arguments, but that was the culmination of 7 months of hard work by these two competitors. And I mean, they were just incredible. So very proud. My name is Juliana Rosenfeld, and I am the chair of this year's Moot Court Board. I just want to take a few more minutes of your time to give a few thank yous. So to the admitted students, welcome. We're so excited for you to become a part of the UC Irvine Law community. We hope this gave you a glimpse of what your future here can look like. One of the things that makes this program so special is the community that sustains it. The Moot Court Board itself is made up of students who have come through every level of the competition, from former bailiffs, octo, quarter, and semifinalists, Best Brief and Best Oralist recipients, and last year's winner. One of tonight's finalists was a 1L fellow just a year ago, and many of the judges who volunteered their time this year once stood exactly where the competitors are this year. That kind of continuity reflects the sense of community that is built at UCI and in Moot Court. Students are not only invested in their own growth, but in the growth of those around them. So, a few thank yous to go around. To the attorneys who volunteered to judge oral arguments this semester, the faculty members who graded briefs, the 3 federal judges who were here with us today, to Leslie Dodds for your support in planning today's events, and to Naomi Aguilar for all of your work in executing the preliminary and elimination rounds, to Dean Parrish for your continued support of the program and the students of UCI Law, to the first-year law students who spent their toughest year of law school as bailiffs on their weeknights, and especially to our 3 1L fellows, Laura, Laura, and Mitch. We're so excited to see you at the podium next year. To this year's board, Lindsay, Danny, Connor, Ahmad, Nicholas, Haley, and Sky, you each care so deeply about your work and your peers, and it's shown in every detail of the competition. This experience has made us not only better colleagues, but better friends, and I have no doubt that the dedication that you've each shown here is exactly what you will carry into your careers as attorneys. We would also like to extend our deepest gratitude to our faculty advisor, Professor Tice. Through countless meetings and hundreds of emails, you've been a constant source of guidance, patience, and support. The effort you put into this program is felt in the experience of each competitor and each one of us. The support you have given the board this year goes far beyond what anyone could expect. You have trusted us, challenged us, and stood behind us at every step. We're incredibly grateful. And with that, please join me in welcoming Professor Tice to the stage to present the awards for oralists and briefs.
Wow. So I had to bring my flowers to show you all. Thank you all for being here. It's so exciting to see you here and to have you be a part of what we just witnessed today. And a special welcome and thank you to our admitted students. You know, just by being here today, you've become a part of UCI Law already. And you know what else? In 2 years, this could be you. I'm serious. So that's something to look forward to. Thank you all for being here. And I'd just like to say a special thank you to this amazing, wonderful Moot Court Board. It takes an entire year to put on this event, as you may imagine. And this group of 8 dedicated people has been working since last April on putting together our event today. And so they have provided me with support and encouragement in helping me be the best advisor that I could be. And we've been together through every step of this, and it's just I feel a little emotional now, guys, with a very warm heart that I thank you all for being who you are and for all the work you've done. Thank you. Yes. And now I get to do one of the best things that the faculty advisor for Moot Court gets to do, and that's to award some people some great awards. So let's do it. I am going to be starting with the Best Brief Award. As you heard, faculty read briefs approximately 3 times, sometimes 4 times, and we amalgamate all those points and scores and come up with our best brief recipients. So the runner-up for Best Brief this year goes to the team of Adrian Roybal and Owen Farley-Klasick. Please come on up. There you go. Thank you very much. Okay, I think we're going to take pictures. Yeah. All right. There? There? Okay. Are we good? Perfect. Thank you. And the Best Brief Award this year goes to the team of Fiorella Barreto and Alex Davis. Okay. Oh, wow. These things are heavy. So grab it. Okay. Yeah. Oh, well, okay. I'm going to check. You got it? Yeah. Great. Okay. Group hug. Okay. Yeah, okay. All right, let's take pictures. Okay.
All right, let me go on your list.
Yeah, okay, good. Got it? Fabulous. Thank you so much. And now on to our Best Oralist Award. Alex, don't sit down, because our runner-up for Best Oralist is Alex Davis. Yay! And there you are.
Thank you so much.
Okay. Oh, great, wonderful. Okay, this way. Oops, whoops. You got it? And our Best Oralist Award goes to Sagarika Chidella. Thank you. You are so welcome. All right. Yes. All right, everybody. And so our judges are still in deliberation. I know they're having a really hard time. So we will just take a brief break while we wait for them to return. Thank you again for attending this year's Moot Court Competition.
Thank you, everyone. You may be seated. So we hope that you enjoyed the Moot Court competition as much as we did. It is abundantly clear how hard and how long you trained for this. As a circuit judge, I can tell you, if you want a career in appellate advocacy, it'll be waiting for you. You both did an amazing, yes. You both did an amazing job. I wanted to give you a little bit of feedback. We all do, so I get to go first. So a couple of things. I loved that you answered our questions. One of my pet peeves as a circuit judge is when I ask a question and the lawyers dance around it. We want an answer to our question because that is the question that we have. And so I appreciated the fact that you did it. And then, you still wanted to make your point, so you tied your way back to making your point. That was wonderful. So it's a great way to see how to do that in real life. When you are before a circuit court or the Supreme Court, if you are insistent that I need to get this other point made because I think it's really going to clarify things, don't say, Your Honor, let me finish my point. No. Your Honor, yes, stop what you're doing, respond to the judge's request or question, and then you can pivot back. You both did a wonderful job with that. I was very impressed by, this is going to sound silly, but by your voice. Neither of you were nervous. Your voice didn't crack. You were clear. It seemed like you were having fun. I hope that's true. Because it seemed like you got in your grooves and you were ready to go. So congratulations. You were honestly one of the best oral arguments that I have seen, even in my professional life as a circuit judge. So yeah. I will now hand over to Justice Jackson.
Thank you, Chief. Well, let me commend both of you. You were both just absolutely outstanding, and I would be privileged to have you all in my court at any time, and I know I speak for my colleagues here. You all displayed the kind of skills that we only hope that all lawyers who appear before us displayed. So you all have very promising careers as litigators or oral advocates. A couple of comments. I think both of you did a tremendous job of establishing very good eye contact. That is absolutely critical that you do that. You avoided the use of notes. You were well prepared, and that's great. This was somewhat of a hot bench, and it's supposed to be in a competition like this. We're supposed to just throw all kinds of things at you, and both of you handled it well. You both did a good job of, I think, returning to your point, even after we asked questions that were sometimes, I have to admit, designed, at least for me, I can't speak, to get you off track, right? Because and that's important because that shows that you were able to get right back on your track, stick to your themes, and stick to your arguments. I would suggest that you just be aware of your gestures as you speak and the pace of your arguments. And it's one of the things that I tell trial lawyers, that when you practice before a jury, you've got to learn how to moderate your voice. Up, down, and pace. So, and the same thing holds true for appellate advocates as well. And again, just trying to be aware of how you're using your hands. One of the things that irks me more than anything is if a lawyer points at me. Oh no, But they don't do it intentionally to disrespect me. Yeah, because and the other thing I appreciate about both of you were very passionate advocates. But as you express that passion for your case and for your clients, you just have to be aware of your gestures. But overall, terrific job.
So it's my turn. Let me just start by saying how exciting this was to watch you in action, because it takes a lot of courage to do what you do. And so I want you to really appreciate that about yourself, that you are very strong people to get up here and do that in front of this audience, which is not how most oral arguments occur. So I'm just very impressed by your courage, your strength, and how well prepared you both were for today's argument. I think one of the things we all know as judges and expect as judges is that those who appear before us, that they present the facts and the law in an honest and credible way. And you both did that. And I think that's something that I just want to highlight, because credibility is really your most important, the most important aspect really of your presence in court is for us to be able to trust you, to trust what you're saying, to trust that you're describing the law in an accurate way. And so I think, again, you both came across as very authentic, very credible, very prepared. And even though you had different positions, your positions were well reasoned, and your credibility stood out to me. Also, your fluency when discussing Supreme Court cases, other precedent, it was clear that you really understood the law, that you've spent time reading these cases. And so one of the things that I think we all enjoy as judges is when you can have a conversation with the advocate. This is not really a test. It's an opportunity for us to learn. It's a hearing, right? We're here to hear your position and to try to understand your position. And so the more comfortable you are up there, the more fluent you are in how you describe the law and your arguments, it makes the whole experience more pleasurable for the judges as well. And so you both achieved that. You were both incredibly fluent. You came across very authentic, very credible, very well prepared. And so congratulations to both of you.
So now I have the enviable task of getting to announce the winner. Before I do that, I just want to say it was an incredibly difficult decision. We went back and forth. We talked about it. We were so impressed by the way that you presented your cases. It was, I mean, you should be very proud of yourselves, both of you. But we found that the winner and the best oralist was Alex Davis, counsel for Petitioner. Congratulations. Absolutely, yes.
Well, with that, could we have another round of applause for our finalists and competitors? And I know but before they leave, can we have a really broad round of applause for our three judges from this evening? My closing remarks are going to be very, very quick here, so maybe we'll do it all and then we can exit if that's okay. We just wanted to remind you that we have a reception that's going to occur right out there just as you get out the door, right? So I hope you'll stay around, grab some refreshments. Otherwise, I just want to announce the two finalists here were truly extraordinary, but what you didn't see was that we actually had a number of 60 other competitors who also were extraordinary, and it makes me as a dean incredibly proud that we see such high level of performance even into the second year of law school. So congratulations to all the competitors. Another broad round of applause for our finalists. Thank you so much. And that concludes this year's Moot Court Finals. Thank you so much for attending.